The question is, could you be guilty of failing to provide a breath specimen if you were trying your best to blow into the machine? Well, the short answer is yes, you could be charged with failing to provide a specimen and you could be guilty of that offence, but there is a defence which I'll come back to in a moment. So this is the usual scenario. Somebody is arrested for drink driving, they're taken to a police station, the police require them to provide a breath specimen, and that person tries to provide a sample but they're unable to do so for whatever reason. Maybe they're not blowing hard enough, maybe they haven't blown for long enough, or something else. The police will normally ask if there's a medical reason for that or any other reason. If one doesn't come to light, then the suspect will be charged with failing to provide a specimen. That's a serious offence. There's a minimum driving disqualification and up to 6 months in prison if there's evidence that that person had been driving. So coming back to the defence is reasonable excuse. So the defence is failing to provide without reasonable excuse. If the defendant can provide evidence, raise a defence of reasonable excuse, then they might be not guilty of the offence. There's no limit to what a reasonable excuse could be, but in most cases that's going to be a medical defence. So some kind of respiratory condition, maybe asthma or something like that, or possibly could be having a panic attack or something along those lines. Now, in order to establish that, there's no point in just going to court and saying, I think that I got some sort of lung condition. You would have to provide medical records. You would probably have to have a medical expert look at those records and write a report, conclude that you're unable to provide a specimen because of that condition. And normally, for that to be reasonable, you would have had to have raised it with the police at the time of the taking the sample, because of course they could always go on to take a blood or a urine sample if the suspect was unable to provide a breath sample. So there are all sorts of things that feed into this defence. But if the court found that there was a reasonable excuse, then that would be a defence, and the suspect or the defendant would be not guilty. I said reasonable excuse isn't limited to medical reasons. Sometimes, and these are very rare occasions, there might be a defect with the machine, most commonly a problem with the mouthpiece. If there's a hole in the mouthpiece, then that can make it more difficult to provide a breath sample. And so you'd have to have the mouthpiece preserved by the police and examined in order to look at that. But to loop back to the original question, if you're just going to say that you were trying your best, then that is not enough for a defence. And just trying your best, if you're just saying I was trying my best, then you're more than likely to be convicted of the offence and face the consequences that I mentioned before.